Maayan Niezna. Maayan, the floor is yours.
Thank you, Hani, and I want to thank, I think, again, and probably not for the last time, to all the participants in today's event for fantastic and thought-provoking engagement with the broader question of today, and especially with our report. And I think it's just the beginning of much longer and interesting conversation that I think we're looking forward to have, so thank you for that. The question I want to address today is what makes trafficking for labor exploitation? And there are different ways of understanding this question and different ways of answering it. We could talk about actions means purpose under the Palermo Protocol, or about criminals exploiting vulnerable victims who lack other options due to due to poverty or discrimination or lack of information of what awaits them. But the way I suggest to look at this question that links with everything discussed earlier is from a structural approach or a labor approach, as reflected in this plan, that recognizes the role of social, political, and for my focus today, especially legal structures. So what makes trafficking is in what enables it. And through recognizing the role of the law, not just in combating, but also in constituting what we refer to as trafficking for labor exploitation. Now, when we think of trafficking for labor exploitation, the essence, the definition I suggest to use today, is a combination of elements of workers coerced into situations characterized by severe exploitation. And asking next what policy areas make trafficking, what I suggest is to look at a tripartite structure of binding, debt, and enforcement. And I'm going to discuss these policy areas and the relationship between them, drawing from the case study of the regulation of migrant workers and Palestinian workers in Israel. However, I suggest that similar issues, even in somewhat different contexts, could be recognized elsewhere, and this tripartite structure of binding, debt, enforcement is relevant to many migrant receiving countries. Starting with debt or tied visas, as Virginia mentioned, as regimes linking migrant workers' visas and working permit working for a specific employer. If they leave them, they lose their visa permit and they risk detention or deportation. And tied visa regimes are a key structural component of trafficking for labor exploitation. And in Israel, such arrangements apply to significant numbers of non-citizen workers, to tens of thousands of Palestinian workers from the occupied territories, especially the West Bank, that are tied to employers mostly due to government concern that their unsupervised presence in Israel will threaten national security. About 40% of the migrant caregivers are restricted from leaving their employers for various reasons, if it's because they've been in Israel for more than 51 months, if it's because they want to move between geographical areas, or leave patients for patients requiring less intensive assistance. And if it's for thousands of migrant workers tied to foreign construction companies, including the company now building the light rail in the Tel Aviv area. In agriculture, the sector where binding was most effectively formally abolished and not reintroduced, not formally, students in so-called educational programs are tied to specific employers. And in all these sectors, abuse and poor conditions are common. And in some, if not all of them, the poor conditions are the main reason binding is needed in the first place. The Israeli context demonstrates an alarming resemblance between official policies and practices that accompany tied visa regimes and private practices recognized under what I'll refer to as the dominant approach as amounting to trafficking. Practices that have been part of the regime, at least at different points in time, included the recruitment and selection of workers from immigration detention, a process that often included physical assessment of their body and health, including at least in one case of their teeth. It was reflected in official exchange rates policies between so-called runaways and quotas for new recruits. And until and withholding of identity documents that until very recently was both a criminal offense under Israel's criminal code and at the same time a legal requirement employers of Palestinian workers had to meet. So there's a clear tension here between the legal and the so-called criminal. The coercive nature of binding is worse when migrants also face significant debt resulting from having to pay high recruitment fees to secure a job abroad. These in turn result from the second policy area of private recruitment, creating significant power gaps between workers and intermediaries with access to the host labor market, recruiters, brokers, or agencies. Workers' vulnerability and dependency are used to charge an exorbitant fees, and in turn they further increase their vulnerability and dependency on employment in the host state because workers know that if they leave their tied employer, they lose their visa, face deportation to a country, or they can never make enough money to repay the debt. And an interesting aspect in considering these two policy areas, one next to the other, is that they could be argued that one of them is a case of too much uncontrolled market and the other of not enough. That tight visa regimes restrict migrant workers' choice and bargaining power and deny them some better options that might have been available to them in the labor market of the host state otherwise. In the Israeli case, the justifications for binding of caregivers, for example, include clear labor market rationales, ensuring that certain employers' patients are free from competitions with others in the same sector that are able to offer higher wages, better location, or easier work. In other words, making sure that what should have been basic considerations of workers in a relatively free labor market are formally excluded from what migrant workers might consider when accepting or changing employment. So this is over-regulation of the market. The reason these workers are still tied, despite the Supreme Court judgment, was that the state and the Supreme Court itself thought these pressing interests that I argue are seen as serving some sort of public good justify what was a few years before considered as unconstitutional and basically a form of modern slavery. Similar state interests or public interests can be identified in other sectors where binding still exists, especially construction. I can say a bit more about this later. In private recruitment, on the other hand, the state provides brokers with a valuable resource, the keys to the gate or the power to decide who gets in and who gets a visa. And then it lets them use and often abuse this resource with very little intervention. And it's important to note that it is the state and the legal regime that provides recruiters and brokers with this resource, just like it is the state that provided employers with the powerful threat of detention and deportation in the case of binding. The state adopted policies that privatize many aspects of migrant recruitment, regulation, and departure. And this is the reason to refer to that as reflecting a policy area. Private recruiters are not simply there. The state constructs power and dependency that they exploit. And this privatization of gatekeeping measures that, again, could have been seen as the core of state sovereignty, whether formally or informally, to regulate recruitment, perform migration control functions, and ensure compliance with legal standards enables coercion and exploitation. Recognizing the active role of the states, its laws and policies in creating dependency and vulnerability is a condition for adopting effective solutions. And there are several chapters in the alternative plan that discuss different aspects of this policy area, especially chapters 4, 5, and 6. And looking at recruitment, we do not have effective solutions yet, and we do not have appropriate legal framework. The existing legal framework around trafficking, slavery, and forced labor is not adequate to deal with the coercive and exploitative role debt and recruitment fees play in contemporary situations. When the exploitation of migrants is for fees rather than labor power, it generally falls outside the existing trafficking framework. And the general approach to recruitment fees within the trafficking framework reflects the argument that I just explained, as fees primarily means of coercion, that falls just outside the legal definition of debt bondage, but works in a similar way. What is not discussed, even in policy generally is that the fees themselves are also a form of exploitation. And from the Israeli case, this was the case of what was known as the flying visa scam, of migrants recruited for either non-existing job or jobs they're clearly unable to perform, especially caregivers with no language in common with the patients that they're supposed to care for. And they were recruited for the sole purpose that recruiters can charge them high fees for arranging a visa. The state did eventually recognize its responsibility for such scams, and some general changes in policy made these particular scams less likely, but the question of fees and exploitation as a whole was not properly addressed. A key change in this policy area in the Israeli context that reflects some of the ideas explored above and discussed at length in the alternative plan is the recognition that private abuse results from official policies or omissions, and following that, the adoption in Israel of government-to-government bilateral labor migration agreements that completely exclude private recruitment. Significant part of the recruitment of migrant workers in Israel, especially in agriculture, Yael writes a lot on that, but also in construction and care, is now part of such agreements. And the impact of recruitment fees and debt of such plans was very significant. However, control and regulation of various aspects of migrants' day-to-day are still privatized. In the case of Palestinian workers, binding and dependency on brokers charging high and illegal fees are two aspects of the same problem. And this is interesting because theoretically, in this case of physical proximity, where language barriers are not too severe, it should have been easier to find a job without brokers. However, a combination of tight regulation, no mechanisms enabling independent job search, and significant external political considerations of the complex situation of the occupation means that many workers are still dependent on brokers that accordingly charge very high fees, and reform adopted in the last 2 years is currently failing and is in the process of being abandoned because it doesn't work. The inadequacy of the existing frameworks brings me to the third and final policy area, that of enforcement. And enforcement is supposed to address exploitation and inhumane condition, and this is a key to the mainstream approach to trafficking. In reality, as pointed out, it's rarely effective. While what we argue here, what I think many of the people here agreed, that the best approach to address trafficking for labor exploitation is the labor structural approach in paying attention to structural factors and preventing exploitation through the change of migration and employment policies. It's important to note that prevention is not watertight. Even with effective mechanisms to promote fair recruitment and fight debt, even with the abolition of tight visas and the extension of all labor laws to migrant workers, and we're not there yet, migrant workers would still be vulnerable to exploitation. So enforcement is necessary. It also needs to be strategic and target the worst and most common forms, discourage what cannot be effectively prevented. In Israel, however, criminal proceedings focused on marginalized perpetrators or sectors considered as illegitimate. First, of course, was trafficking for prostitution, where very effective use of border control and criminal proceeding resulted in almost eradication of this phenomena. Outside this context, the very few cases prosecuted concerned either the examples of family-like cults where a charismatic man abused his many wives and children and forces them to work, or another group of cases against members of ethnic minority, such as the Julani case of Palestinian couple from East Jerusalem charged with holding their domestic worker in conditions of slavery, and more recently the case of Bedouin men in the Negev charged with slavery and forced labor of their young relatives in the family business. The focus of these cases reflects attention to exceptional, sensationalist, and marginal cases that do not reflect on the mainstream labor market, on state policies, or on common employment patterns and practices. The largest sectors employing migrant workers, care, construction, and agriculture, there are no prosecutions, almost no investigations, and victims are often not identified. And this area again raises the issue of the state and the market. And here too, one could argue that impunity is a resource that the state grants employers, but it is also a valuable resource that the state grants itself. In focusing on exceptional and sensationalist cases, it allows the state to maintain that trafficking is exceptional and outside the market, rather than common and constituted by law, at least as much as it is constituted by criminality. And at this point, without claiming to offer a comprehensive response to Joel's fantastic and crucial questions, I think the question of how far we can stretch trafficking, I think it's a fair question. It's a question also of what amounts to stretching trafficking. And it depends on whether the concern of stretching trafficking, is it a concern of conceptual clarity? Is it a concern of using a dramatic label for behaviors that are just not severe enough to justify this dramatic language? Or is it turning a label that was made for exceptional practices to one describing entire sectors or subsectors of the labor market? Meaning, is it a question to some extent of numbers rather than substance? And from my perspective, it's true that there's clear element of stretching trafficking in this work, without a doubt. But there's also an element of pointing to a fiction, because many of the practices characterizing whole sectors and many of the practices that I gave some examples of earlier would have been considered by prosecutors as trafficking if there weren't just so many of them. So I think this is also a question of what happens when we take something that was built for exceptional and either apply it to broader structure or saying this was never exceptional to begin with. And I think I'll stop here and we can continue this in the discussion.
Thank you so much to all our speakers for laying such a rich and thought-provoking basis to discuss. We now open it up for questions. Please feel free to raise your hand with any questions to any of our speakers. Gilad, do you want to start us off?
Yeah, so I think maybe to warm people up before, I'll just maybe address some of the really great issues. So first of all, again, from my side as well, thank you so much for all of you for coming and for the great work and research you all are doing throughout the years. So it's very exciting to see you all here, even though not in person, but still. And I think, beginning with Joel's questions, I think the questions you asked us are really questions that haunt us in a sense as a group and in our individual writing. And some of them, Maayan, I think, addressed it in a very powerful way just now. And I'll just give you my take a little bit about this. And I think, Beyond Trafficking and Slavery had this really very, very fascinating and important special project on, are we better off on the inside or on the outside? And I think that's a question we are constantly asking ourselves and finding, at least many of us finding ourselves definitely opting for the inside, in the sense that not because we don't see the problems in the trafficking discourse, but because we want to use the tools that are available to us. And this is a tool that is available to people who are concerned with exploitation of workers in the labor market. And there are not many tools that are available to people interested in trying to work with governments and with policymakers around these issues. And I think a good example from the Israeli case can be the case of Palestinian workers. Palestinian workers are not recognized as victims of trafficking in Israel, though they are recognized as a bound workforce. They're bound to an employer, and there was a reform that Maayan mentioned that is probably currently collapsing as we speak, of the binding or of their tight visa arrangement. But I think although trafficking was, the whole anti-trafficking apparatus as such in terms of shelters and police prosecution, kind of the traditional anti-trafficking apparatus didn't operate in relation to them, the alternative one did. And I think it's the alternative one that pushed for this reform. Of course, in the Israeli context, I don't want to say that it has that much power, because there are other interests as well, especially in relation to Palestinian workers. But I think we can see a group that its workers' rights was considered a non-issue in a lot of Israeli policy circles, and through the discourse of trafficking became a big policy issue, something that the government anti-trafficking apparatus is working with and on and is interested in. So I think, we do see those moments where such change is happening. Of course, it's always with politics. It's never outside of politics. It's also always within the limitation of politics. But I do think that it offers a vocabulary that it can be perhaps sometimes a double-edged sword, but can also, as Joel said, create coalitions, create interest, lead policymakers to discuss issues that otherwise wouldn't be discussed. So I think it's not just in terms of, Joel asked us, is it a tactical path? Is it a tactical question? Are we creating a parallel path? And I think, at least in the context here, our goal is not to create a parallel path. Our goal is to create the path. Noting, as Maayan just said, that criminal law, at least from the understanding of many of us in this group, despite its downsides, is extremely helpful to pursue the most extreme cases, but they're few, and it's a tool that's helpful to have there. And I think those of us who've been studying the Fair Food Program in the US have seen how they utilized it very usefully to galvanize worker power and to bring workers together through using criminal that extreme tool, but not for the day-to-day of exploitation. So I think the idea is not to create a parallel path, but to complement, expand, and switch the frame. Really create, in a sense, a form of a shift. And I think, Professor Moulali, who was speaking here before, I think we can even see in the work of the UN Special Rapporteur a shift in the way it's happening. In the Trafficking in Persons report, a shift. There's a shift is underway. I don't want to be too optimistic. I don't think it's it's going to win the day. As Professor Moulali said, the criminal approach still gets more traction. But I think, a lot of us here have been working on it for years in various contexts, lots of NGOs, in the Israeli context, Kav La'Oved, Amoked Leplitim V'Mehagrim have been at this for years and years, leading to changes that are very real changes, using structural solutions as the main way to address these issues. So, in that sense, maybe I'm overly optimistic in saying this, but it's not like I think it's necessarily gonna win the day. But I think we carefully can point to some changes. And so, that's kind of a key thing I wanted to address. And in this element, I think that the political mobilization is an issue. It's another question that Joe asked us. I think it is an issue, and I think trafficking, it can be a way can be really harmful for political mobilization and can be helpful, and it really depends on context. I don't think it's the same in one country, from one country to the next. I can say, in the Israeli context, that sex worker organization Argaman is still kind of trying to decide whether they want to be in the inside or on the outside, being left out in the outside so long, but they are managing to create coalitions through this language as well. So I guess it's very context specific. So maybe I will there's still so many questions. And I think I have to say that I totally agree with Joel that we should have included sex work in this. Putting it again in a silo is something that I myself regret. And it comes from stems from the fact that we were not all in agreement, I think, about kind of taking a full labor approach to sex work as well. Though in the work of TraffLab, we have been supporting the sex workers organization in Israel and trying to at least get their voice heard in these processes, together with many other actors and activists. But you're right, and I regret it. So let's, Virginia, I see you have your hand up. We can just make this into a conversation. I think we're small. Everybody who just wants to raise their hand, jump in.
Yes, and also if others want to participate, please do. I raise my hands because I have things, but I also wanted to hear from others. I've loved all the presentations and your response now, Hilaine. I think I like the way you're optimistic on the one hand. I really like that. And we have to be, because we're all trying to, as well as being academics mostly here, we're not all academics, I know some activists in the group, as well as being academics, we want to change things. We're also some of us are into activism, so it is great. I also liked very much what your response to, all your response now to Joel, and it's a discussion that I've had with colleagues who are here on the Zoom, or one of them told me she would be in and out, Kate Roberts, who works at Flex, the Focus on Labor Exploitation. It's called a very important organization in the UK, and she previously worked in Kalayan, this NGO on domestic workers, and we were always a bit concerned about using the modern slavery discussion in the UK. When the Modern Slavery Act was being passed, we were thinking, is it a good idea to call what is happening with domestic workers modern slavery or not? And we thought, yes, we have to use the tools that we have. You are right, there are few tools. Domestic workers are very under-unionized. They're hardly unionized. There are some powerful organizations of domestic workers, but they're not that powerful. I mean, they're hardly represented in politics. So at times, yes, at times, these have been difficult decisions, both in activism and in academic scholarship. But I think I have also preferred to use the tools I had, even though I understood that there were limitations. I will just say that for now. I want you please to also answer my question, if you can, afterwards or even later, on the visa. How come? So I know, from academic literature, Einat Albin's piece in the past and Maayan's now, and I know that the Supreme Court in Israel said that the visa constitutes, slavery, it's incompatible with human dignity, etc. But you're saying in the report, and Maayan in her article, that there are now not exactly the same visas, right? But other visas that tie workers to the sector or to a particular geographical area, but not as restrictive as the old one is. So this is my question. And yeah, I'll lower my hand.
Annie, would you like to answer that? Wait, you're on mute.
Sorry, again, maybe we'll take Fevor's question.
Yeah, sure.
Fevor, go ahead.
Kate has her hands up as well. So Virginia will definitely answer it.
Hi, thank you everyone for such amazing presentation. I really like the idea of bringing forward an alternative approach to anti-trafficking from the labor perspective. I think it addresses the structures and the underlying factors that make migrant workers vulnerable to trafficking from my own point of research. I guess my question or questions are, one is that does this alternative approach signify maybe the creation of a silo? Does it signify like the siloing of different anti-trafficking approaches? How does it interact with the predominant approaches? How does it interact with the human rights approach, for example, in terms of its interaction with other structural approaches? There are ongoing conversations on the role of the finance sector as a contributor to the vulnerability of workers to trafficking, and also as a means to address it. Looking at migrant workers, for example, on the sending side, there's this big push of microcredit and microdebts as a way of creating resilience to vulnerabilities for trafficking, an idea that has been pushed by Professor Mohammed Yunus. So is there a way, is there an interaction with this perspective with other perspectives also that look at structural factors or structural factors that engender or embed vulnerability to trafficking, especially for people who are at the lower rung of arbitrarily created social hierarchies or labor hierarchies? So thank you.
Kate, please, maybe we'll do a, yes, go ahead, thank you.
Thanks, and thank you, Virginia, for your kind words about Flex's work and Callie Ann's previous work on the domestic worker visa. I just wanted to really add to that discussion about the insider approach versus the outsider approach, to just very briefly say a couple of words about the current context in the UK, where we're now seeing even, where what we're having been quite critical of the UK's anti-trafficking measures for many years, we're now seeing really some very basic entitlements being rode back on with our Nationality and Borders Bill, and we're fairly apprehensive about a forthcoming modern slavery bill. And certainly in the Nationality and Borders Bill, we saw, anyone of you who follows the UK would have seen there was a real narrowing of identification and support measures. So we're now in this interesting situation where organizations which, where when you having taken a fairly insider approach, those mechanisms are really now becoming so narrow that they're open to very, very few individuals, or once they're being applied in secondary legislation, it looks like they will be open to very, very few individuals. So I guess you can make of that what you like. I think it does say it's why it's so important to, while even taking an insider approach, to keep maintaining some of the awareness of the structural issues around trafficking, because it can backfire when the trafficking legislation becomes narrowed.
Thank you, Kate. Unless there are any more questions by Janie, please.
I don't have a question, but I did want to comment on the insider outsider question. I think here in the United States, the anti-trafficking movement, labor advocates were not in it in the beginning, right? And they actually resisted having anything to do with the trafficking field, in part because they viewed it as an issue that just sucked all the oxygen out of the room. It would devolve into debates over sex work versus prostitution. But I think maybe 5 or 6 years into the modern regime, there was a recognition that that's where the money was for projects. And so I talked to labor advocate after labor advocate, and they say, well, we pitch a project to a funder or a government entity, and we wouldn't say trafficking in it, and we get no money, but we pitch the exact same project, same goals, same same methodology, and we put trafficking in the title and we get money. And so I think the reality is you work with the tools that you have, but you have to have a really clear-eyed view of some of the unintended consequences, right? So the use of modern slavery, great for mobilizing outrage, but at least here in the US, it's also backfired in actual cases. So defense counsel can invoke the message or the imagery of people working in cotton fields to say, this case, which is clearly of trafficking, but it doesn't involve working in a cotton field and in chains. It involves more sort of subtle forms of coercion, like debt bondage. Defense counsel have been very successful at using that slavery imagery to deny or to actually lift the threshold for trafficking, right? To say that it's only trafficking if it reaches that extreme of what we think of as slavery historically. And so I think, in all of these instances where you're trying to, claim a lane in the inside, you just have to be really, really, really cognizant of how it can backfire in all of those different ways. And that's a product of talking to advocates. I think as scholars, it's really important to, as TraffLab clearly is, really tied to people on the ground who can tell you, well, yeah, this is useful in this way, but it's also really, these are the sort of hidden ways in which it actually backfires on us. And we've got to sort of navigate that. So I think it's not a black or white question, right? It's a question of it's not a question of whether you do it, it's how you do it, right?
Thank you, Janie. We are almost out of time. We'll take one more question and then we will allow all of the speakers to respond to the great questions and comments that were raised. Chris, please.
Yeah, I think can you hear me okay? Okay, I think I had maybe a question or comment that sort of dovetails with what Janie just said, which is, as someone who's done like community organizing and all sorts of like just grassroots anti-violence work and all of that, I worry, like I see that we need to have the frame expanded, as other people have been saying, and look at the broader picture. And also what I've seen happen sometimes in practice in the US is that then we have anti-trafficking advocates doing human rights work poorly instead of human rights activists and advocates and professionals doing the broad work. And so, an example of that is, thinking of LGBTQ rights and then anti-trafficking advocates coming in and like reinforcing really transphobic and homophobic narratives in the way they talk about trafficking, or looking at like forced labor and then some of the anti-trafficking work that is being done, reinforcing racist stereotypes about migrant workers in the ways that they talk about forced labor and agency. And so I'm wondering, like, how do we balance, or do we balance and account for the fact that as we try to encourage anti-trafficking advocates in different countries to think more broadly about the social context in which forced labor in any form of labor, including commercial sex, happens, that may then invite them into places where they're just gonna F it up. Because I don't want to encourage that. And also, I recognize that this exceptionalism and singular focus on trafficking as this unique harm out of context is also harmful. So, yeah, I find myself kind of wanting to tell some of the anti-trafficking people I meet here in the US to stay out of those spaces. Because they're just going to co-opt the language and wear it around like a funny costume while still doing harmful things. I would love to hear what some of the speakers had to say about that.
Thank you very much, Chris. So we will do it in order of presentation. Joel, go ahead.
Yeah, I'm going to try not to take up very much time at all because I went over. I just want to say that I don't feel like the inside outside thing should be something that we decide is a yes no binary. It's always contextual and contingent and case specific. what I would say is I think there's value in having explicit and sustained conversations about tactics and strategy. And I think that people are often reluctant to make those kind of calculations public, because when you make them public, you run the risk of undermining your strategy. But at the same time, I think if we want to play the long game, those conversations need to be about what works and also what doesn't work, because this field as a whole has an absolutely awful record about holding your hands up when things don't work. And if we can't hold our hands up when things don't work, we don't have a good learning curve. So I guess that's all I'd say there.
Thank you, Joel. Janie, do you want to respond or conclude?
Yeah, I agree with Chris. Yeah, I feel like, you know, I find myself often thinking, you're not an anti-trafficking advocate. Like, you can't wear that because of the, you know, I think this comes up in the US a lot when particularly around sex trafficking. You've got, you know, this strange bedfellows of neoconservatives and radical feminists, you know, who work together in the Bush administration under the rubric of trafficking to really cabin the rights of sex workers. So I agree. I think it's problematic that so much can be pursued under the label of trafficking. And I think, you know, for me, it's just been a matter of having people explain what exactly is their approach. Are they a rescue and rehab organization? You know, is this a moral crusade to rescue people from the vices of prostitution and sex work? Or, you know, what does aftercare look like? You know, you claim training for people to get out of the life, and what does that look? You know, so I think it's not accepting the labels, but, you know, forcing them to answer questions about what exactly their strategies are, and just always having a really critical eye on it. So I don't know, the US is a hard place to be these days in terms of rights, having just lost our right to abortion for many, many millions of women here. So I think you just have to soldier on.
Thank you, Janie. Virginia?
I don't think I want to add anything. I've just really found the discussion really thought-provoking, and it's great to see how we're all motivated by similar concerns. And it's great to see Hila and TraffLab, everyone doing great work. So thank you for this, and thanks for the opportunity today. That has been a fantastic discussion.
You asked one question about the 2006 verdict. I will reply just in one sentence because it's really a long and sad tale. But basically, it's a tale about the life of a legal precedent once it's decided. This was a festive victory seen, you know, at the time it was given as a monumental victory, really. But time has proven that its enforcement in reality has not been entirely successful, and it hasn't been, I think it wasn't more than 5 years since it was given that the Supreme Court has actually retracted and decided that binding is in fact okay for the care sector. So there's been this pendulum and thinking about binding and sort of a zigzag by the Supreme Court itself. And, you know, even in areas where this was, the prohibition on binding was not disputed, like agriculture and construction, it was not really implemented in practice. Mobility did not become a reality in these sectors for various structural reasons that some are detailed in our report, but if you're interested in more information, I will be quite happy to share it. I've done extensive writing on this subject. And finally, Maayan, go ahead.
Thank you. Yeah, I think one quick thing that I'll add to what Hani said is that one of the things that happened quite quickly after the amazing judgment in 2006 is the court realized that it has done too good of a job in addressing binding, and it found that there are various situations where the interest presented by the states or by patients or by employer was seen as an important interest if it's in the term of care patients, also if it's in the term of international relations and armed trade and security, that the court couldn't see, the court and the state couldn't see an alternative way to achieve these interests other than return to binding. So there was adding of exceptions at some point with very little legal justification as to why it is the case. And for Palestinian workers, interestingly, this was never discussed for years in the context of Palestinian workers. So one of the things I did in the recent paper was try to figure out what happened and how this language of binding migrated to Palestinian workers. I'll try to put a link to the paper later. One quick thing that I want to say, and it follows from one of the things that said earlier, and one of the things that Joel said about the insider outsider, that it's very context sensitive. And it's important to remember that I think oftentimes when we make this conversation, we have this conversation with a very strong US image in the background, and not all of the anti-trafficking and anti-slavery is happening in the US context. If it's in terms of focusing on labor exploitation, that, for example, is way more significant under the Modern Slavery Act in the UK. If it's in terms of to what extent the public or other politicians or stakeholders buy the mainstream anti-trafficking narrative. I think in the UK, the government uses the modern slavery framework for various things. It's a big question whether the public or politicians in the opposition buy the narrative that migration control and deporting migrants and making work illegal is part of fighting modern slavery. Many will point out that it goes exactly against protecting people from modern slavery. So to some extent, these aspects of the structural understanding, they're not necessarily consistent, they're not necessarily coherent, but they exist even in places that we don't immediately think about when we talk about the dominant approach. And I don't want to sound too optimistic, but I agree it's a lot more nuanced, and I think there's a lot more to do in this framework, taking into account that for some agendas, it's not like we have many other options.
Thank you so much, Maayan. I want to thank everyone for your participation. This was such a fascinating and thought-provoking conversation, and taking stock of this moment that we're in, both in our thinking and in our policy thinking. So thank you all so much for participating and for engaging with the Alternative Anti-Trafficking Action Plan. And we will, of course, continue this conversation in the future. So thank you all so much again, and good night.
Thank you.